from Wolters Kluwer. Before we begin today's webinar and introduce our featured speaker, I just want to cover a few quick housekeeping items. Please use the Q&A menu bar located on the GoToWebinar menu on the right side of your screen to submit questions. All lines have been placed on mute. To download a copy of today's presentation, you will need to use the URL that was sent out in the reminder email this morning, or use the link posted in the GoToWebinar chat box. For CEUs, today's webinar has been approved for 1.2 hours units from the Healthcare Compliance Association. An email with a survey and download instructions will be sent within 24 hours of the webinar. And now I would like to introduce Faye Rozovsky, President of the Rozovsky Group. Faye is an experienced risk management consultant and attorney with a master's in public health with an honorary doctorate in public health from Providence College. She has published more than 600 articles on subjects in health law, risk management, patient safety, and medical ethics. With more than 18 books to her credit as an author, co-author, or editor, Faye is known as the authority on consent to treatment. Her treatise on the subject, Consent to Treatment, has been cited by the highest courts in several states and the United States Supreme Court. Faye?
Thank you very much, Jenny, and good day, everyone. We've got a lot of material, so I'm going to jump right in on this topic and introduce our objectives for today. This is not an in-the-weeds presentation on the legal nuances of reimbursement. We're going to talk about some of the coding and billing issues, but through the filter, or a prism, as it were, of risk management, enterprise risk management in particular. And so the first objective will be to look at clinical and enterprise risk exposures in telemedicine. And then we'll talk about some of the potential outcomes that can emanate from these kinds of risk exposures. And not leaving you in absolute distress, we're going to talk about some of the practical strategies that one can exercise, whether they're in a hospital setting, medical group, long-term care, on either side of the spectrum, either as the site receiving telemedicine services or the one providing it from a risk management perspective. What is telemedicine? There are so many definitions. Go out on the internet and just do a search and you'll find some. The largest trade association group, one that is also now involved in an accreditation program for telemedicine, is ATA, the American Telemedicine Association. And they use this definition. It's an information exchange from one site to another using electronic communications. And it includes two-way communication. It can be through video or email, could be the smartphone or a tablet. So we're looking at a variety of platforms that allow for the exchange electronically, two-way street of information. How does that differ then from telehealth? A lot of folks use the terms interchangeably. Here is HRSA, the Federal Government Research Administration, or HRSA. This is the group that includes all the requirements for the federally qualified health clinics. And they're a large group. HRSA is also the mothership, as it were, for the National Practitioner Data Bank. So they're using this terminology. It's the use of, guess what, electronic information and telecommunications to support long-distance clinical care. And now they are adding the context of education, public health, and health administration. So it's a bit different, to say the least, from what we've just seen from the ATA. Do you see a distinction here? The latter, telehealth, is much more broad-based. And yes, we are using the wherewithal of the electronic systems to do more health education for patients and their families. Home health is a good example of this. But it's also being used in rural healthcare clinics, public health clinics, the look-alike and actual federally qualified health clinics, doctors' groups, urgent care, walk-in clinics as well. So it may be a tempest in a teapot, and maybe not that. CMS also has gotten into this. And you'll notice that they acknowledge that there is this interchangeability of the terms as they use it in their work. So that's yet another aspect or another dimension. Telehealth to them is something that might also be considered part of telemedicine and vice versa. Well, on slide 7, we can ask ourselves collectively, are we trying to split hairs? Are we trying to count how many angels can sit on the head of the pin? ATA and CMS seem to be using the terms interchangeably, but then as many lawyers, and many are on this presentation today, myself included, one of the things you're taught in law school is the notion of precision. Make sure that you're using terminology that is consonant with enabling laws and regulations. And as we try to gloss over the differences or reject nuances, we may run afoul of applicable laws and regulations. So it's important that while people can say, oh, what the heck, I'll use that term broadly, remember that it can have implications not only in terms of regulatory risk for an enterprise, but also for reimbursement purposes as well. And it's a public policy issue. It's probably going to be something that's going to take time to iron out so that there can be some kind of congruence on how we define things. Well, that's all well and good. That sets the context, and it sort of reflects the fact that as we start talking about telemedicine risk exposures, we're talking about the wild, wild west of contemporary healthcare. What began a number of years ago, and I can remember this when I lived in Canada in the 1980s with a cardiologist at one of the leading teaching hospitals in eastern Canada, receiving EKGs via fax and then doing a two-way conversation about the findings with a physician in a rural hospital in New Brunswick, Canada. That was really the beginnings of telemedicine for them. They've gone far afield of that now. And telemedicine is so much more today in so many different venues. But again, some folks might call that telehealth. So what are some of the key clinical risk exposures? We'll start with that first, and then we'll move on to some of the other risk exposures that are not simply clinical. And I'm going to use the term here, telemedicine. First and foremost is the hot button issue of licensure. It is one that's getting a lot of focus these days because many states will require a physician who is licensed in one state to obtain a license in another state, which means reapplying. And initiatives, as we will see, are underway to address that kind of concern. There are standards of care and negligence considerations. Just as surely as a care provider can be the subject of a liability claim for failure to meet the standard of care in person, why not the same being true through telemedicine? Scope of practice is very important because it's not just physicians, folks. We have people who are doing things like RAD PAs. That is a designation in some states. They're radiologic technicians who are actually physician assistants. And is this within their scope of practice? Consent is an issue for patients. And how do we credential and recredential these people who are involved in the process of telemedicine services? So that gives you some flavor at the 60,000-foot level. But here is the hornet's nest. And this is one that is now going to pick up steam. If you're not in the 7 states or 9 states now that are signatories to what is called the Compact, the Interstate Medical Licensure Compact, your state very well soon may be. They needed 7 states to sign up, and the magic button was pushed when Governor Bob Bentley, who's a physician from Alabama, signed into law the acknowledgement of the Compact, and that triggered the establishment of the Interstate Medical Licensure Compact Commission. They've actually got a document out there on what will be required, and I've given throughout the entire presentation URLs to all of the things I'm referring to, so you can look at these up yourself. They are going to come up with what they think is a streamlined process so that doctors can operate in multiple states. This is not rocket science. Nurses have had this for a long while, but in the context of telemedicine, this is a big step forward, as many see in the industry, to what has been a hurdle to greater implementation. It means, however, that you're still going to have to abide by the laws, the regulations, the rules, interpretive components of where that patient is situated and the practice of medicine occurs. So you may be licensed in Nevada, use that as an illustration. Your patient is over in Utah. You're still going to have to meet all the requirements. And the actual compact document, the model, available through the Federation of State Medical Boards, is on the bottom of this screen. That's the link to go and see it. It's an interesting read, and there are websites, too, that the Federation have, as you can see in the middle, that talk about some of the myths surrounding this compact. But the point is, this is one risk exposure that may actually be mitigated if all the states or more states sign on. What about negligence? Have there been cases involving telemedicine providers and negligent care? And the answer indeed is yes. This one is taken from a situation that occurred in New Jersey. A youngster was in a schoolyard tiff. He was smacked up pretty badly enough that he was taken to an hospital's emergency department. And initially, they didn't think too much of all of his injuries. He had contusions, he had bruises, he was complaining of certain pains. But as time progressed, the only ED physician in the building on that occasion became increasingly concerned and thought maybe this kid's bleeding. So he ordered some x-rays to be done. The radiologist was not in the building. The radiologist was allowed to practice remotely. Welcome to Teleradiology. She would receive the images taken by the rad tech at the hospital, and those would be sent to her so she could look at them from her home on her laptop or on her desktop. She did not know, however, there was no communication to tell her that more than one set of images had been taken of this young lad. She did not tell, in turn, the hospital that even though she was the on-call, she was taking some time off and going to awake. She was away for a while. And when she came back, she found on her computer the second set of images involving this youngster. And that's when she discerned that he had a significant problem. She let the hospital or the ED physician know, but by that point, things were too far, too gone, and too late. This young man was so unstable he could not even be transported, and he died on the operating room table. Was there a duty of care here? Yes, to do this work in a timely, efficient, effective manner. Was there a breach? Absolutely. Did that delay in care result in last clear chance being obliterated? Was there a breach, and was harm foreseeable? Most likely, yes. But think about it in this way, too. What about professional discipline here? Could this physician's license be on the table for professional misconduct in leaving her post as a teleradiologist? And what is the responsibility of the health facility who had her being there in that pivotal position? Did they have a responsibility to the patient under their state licensure? Could this be considered a jeopardy issue? So it has many different talons, but the point is, yes, negligence does occur in telemedicine. Here's another example. This is one that I've created for you. Here we have a 67-year-old person at a critical access hospital who needs an MRI with contrast dye for the abdomen. The remote radiologist is doing the study. This is another telemedicine example using radiology. We could put in other things too, because telemedicine is being used in dermatology, cardiology, psychology, psychiatry, and neurology. The remote radiologist is going to do the study, but he's doing it based on the order of the primary care provider at the critical access hospital. On this occasion, the rad tech, who would ordinarily be accountable for doing the hands-on work was not available. Their backup plan was to have an RN who had done some in-service training utilize the MRI machine. Now, the remote radiologist is in another state, and he is working on the assumption that the primary care provider and this nurse have done the preliminary work that one would do in an ordinary course of doing an MRI. That is to say, getting a good patient history to discern if there are any risks that could rule out not only that MRI, or an MRI where contrast dye or contrast media was to be used. So he was working on that assumption, and they push the IV contrast dye. The patient has an adverse reaction. It's called NSF. And only after he was transferred, the patient, to a tertiary facility for treatment, did the remote radiologist learn that this patient should never have received that contrast dye because he had one of the well-known contraindications, impaired renal function. So you can see that we can have negligence. Here's somebody who was carrying out the MRI. Was that job description for the RN such that it included that she would do this kind of work, or was she exceeding her scope of practice per her job description? One might even ask in state law. Did the primary care physician meet the standard of care? By failing to screen and ordering a known contrast dye with complications, that could be negligence. And again, might be the basis for someone to take a sanction against the primary care provider. And if the patient was in one of the jurisdictions that required the telemedicine provider to be in the same jurisdiction, and in this case they were not, that is to say the hospital knew or should have known that the remote teleradiology provider was not in the same state, do you think perhaps that the insurance carrier might issue a reservation of rights not to defend the claim because the hospital was in denigration of state law? It was violating state law, and it would be against public policy to remunerate somebody or reward somebody for doing so. So that shows you just one context for kind of risk here. Telemedicine consents are important. There are some states that have laws on the books right now that talk about what's required. And on this screen, you can see what would be part and parcel of it. Obviously, having just used an example of getting medical history, that is a critical threshold to make sure. Patients should understand, too, if there's going to be any costs out of pocket, not covered by their health plan or insurance. And in today's world, with patient safety as an overarching umbrella, we would recognize the importance of doing a teach-back to affirm that we've gotten the right information from the patient and they understand what to do. One would have to look at state law to see what are the requirements. But in addition, the Federation of State Medical Boards last year published its own recommendations in its updated policy on telemedicine, and these are worthwhile exploring as the basis for consent and telemedicine. If I fail to meet state requirements, I can be in trouble. I could have negligent consent. But there are other things that are coming up too. Some of the recent initiatives at the state level to basically circumscribe the ability to conduct voluntary therapeutic abortions are attempting to take away one of the telemedicine tools that has been in place in some jurisdictions. Many of the states require that the patient have a counseling session, a consent session with the physician before they have a therapeutic abortion. Some include in this a visualization by the patient of an ultrasound of their abdomen to show them the development of the fetus. And I'm not getting into the debate of whether you're pro or con here. I'm just laying it out as exists. And some of those laws also have a waiting period. They also have had the telemedicine, they've had the in-person requirement, or not had the in-person requirement. And those that have been silent on it, some of the care providers have said, well, instead of making that person drive 300 miles one way and back the other to talk to me before they have to wait 2 days to have the therapeutic abortion, why don't we do this using telemedicine? And now some of the new state laws are taking away the ability of the abortion provider to do the telemedicine counseling requiring in-person. This is now starting to raise the question of whether or not this is a violation of free speech. So this could be a First Amendment issue down the road, or it will be challenged at least on that basis. It's also important not to forget that patients receive information about alternatives, like in-person, and what that would mean for them. For some folks, it's going to be an arduous task. They may be part of the sandwich generation where they're caring for an elderly relative in the home. They've got school-aged children, and they have no one to babysit or do the transportation services to the soccer game. For them, the optimal is telemedicine, but they still should be told of the alternatives. And if there are costs associated, that too can be a factor that some patients will contemplate and decide that they'd rather pay and have the telemedicine or rather get in the car and go somewhere else. The absence of this kind of information is what creates the consent risks, in part, in telemedicine. Another big issue, and this is one that got a lot of attention 3 years ago, was or 4 years ago now, and that was the whole discussion of the conditions of participation for hospitals and critical access facilities dealing with credentialing and telemedicine. This is the final rule. It's a screenshot of it. Obviously, it's several pages long. The URL to it in the Federal Register is on slide 17. It offers two different roadmaps, as it were, for telemedicine services if one is working in a facility that comes under the conditions of participation for hospitals or the CAH's critical access hospitals too, Medicare and Medicaid programs. One is that one hospital can provide the telemedicine to another hospital, and they can provide credentialed, privileged providers to do the work. The hospital where the patient is situated would have to accept this. There's a written agreement, and it has to be approved by the governing body, and the medical staff will probably want to sign off on it. There is a quid pro quo here, however, in that the hospital where the proxy care providers are going to do the actual work of interpreting, they must receive from the hospital where the patient is situated information about quality, about outcomes, and about adverse events. And they're going to use that as part of, if you're a Joint Commission, OPPE or FPPE, or if you are accredited by HFAP or you're accredited by DNV, you're going to have a credentialing process, and there may be need for peer review, not only under state law, but under the conditions of participation in Medicare and Medicaid. So you do need the data. The issue is this. If we go back to the first example in the negligence case, where the patient was harmed by the contrast dye, and that's being done by a telemedicine provider at another hospital, and they want information, how does the hospital where the patient was situated deal with its incident reports and any kind of potential compensatory event and legal documents that they don't want discovered, that they want to protect, or not admitted when the patient sues them, when they have voluntarily relinquished the same information by contract to the hospital that is doing the work on their behalf? And could that be argued by the plaintiff as a voluntary abrogation of evidentiary privilege? So many law firms have struggled with this, and they've come up with a variety of ideas on how to handle it, but it remains an issue. The other model is the freestanding telemedicine providers who would then do their own in-house kind of credentialing and privileging. They need the data from the place where the patient's situated, but it's all a one-way street. And one can have an issue when it comes to who is doing the actual telemedicine service. I'm going to share with you a very brief illustration. I had a client a number of years ago who had a situation in which their acute care facility had negotiated contracting out all of its radiology services to a medical group. All of the medical group had privileges at the hospital. They were all credentialed and privileged there. That's a typical model. But what they did not tell the hospital was that they had contracted themselves with an overnight reader group so that none of them had to get out of bed at 3 o'clock in the morning. They had a backup group located abroad who would do the work for them, and then they would do overreads the next day at the local medical group. When the hospital risk manager got wind of this, he was quite concerned because when he looked at the deck page on the insurance, they required to have insurance coverages, it said, "See attached." And this was what was presented to him by the practice administrator of the contracted radiology group who did have privileges, the doctors there. And they asked for the information, the similar information, for the contracted overnight reader. That group, in turn, provided its insurance declaration page. Now, on the declaration page for insurance, one will see the name of the insurance company, the type of policy, and the named insured. In this instance, the overnight reader group had on the declaration page of their insurance, "See attached list." And that list had 25 names on it that presumably was being credentialed by that standalone reader group. But there was no date on when they were credentialed, no date on when the list was generated, and there was no mechanism to ask how frequently the list was updated. So they really didn't know or have a clue as to who was doing the work if some of those folks on the list had turned over, and those lists tend to turn over. Can you imagine what that information would do in the hands of a plaintiff's attorney? In the federal rule that you see on slide 17, it talks about giving the list. But again, it's left wide open about how frequently the list is updated. That, ladies and gentlemen, is a risk management issue involving telemedicine and credentialing. So who is conducting the work on your patients? When is the list updated? Do you have that in a contract? Did the patient authorize using an outside group? And if they didn't, that could be a consent problem. Are there any names on that provider list furnished either by the hospital where the radiologist, dermatologist, or whomever it may be is located, who is now debarred by Medicare or Medicaid or under investigation that the hospital where the patient is situated does not know about because they've turned the keys over to them, to the remote provider? And if they're debarred and you let them carry on doing work, what does that do in terms of your hospital compliance program? The other issue, of course, is this information about data going in a one-way direction. Now, there are some significant legal regulatory trends, too, as if what we've already discussed is not sufficient for you. Who's running the show? Is it the states, the individual 50 states and our territories, or is it the federal government, or is it both? Who's collecting the data? How are they using the data? What protections, if any, inure to this data? And by the way, for those of you who are attorneys, if you're sitting on top of a telemedicine program, have you figured out how you're going to address telemedicine in your e-discovery and legal hold programs? That's one for the risk managers too. When I said before, definition is important, and sometimes we sort of wax over it, this is one of those areas where if you're not sure what we're talking about, then you could end up in the skewers of federal financial constraint. This one has been on the books on slide 20 for many years, and you will see it was last updated. It was revised in November of 2014. It's found in the Medicare Beneficiary Manual, and it's a little provision, very small provision, that basically says services not provided within the United States. This is where the overnight reader problem can create a risk of fraud and abuse. If a radiologist who practices in India does the imaging analysis that's done on a Medicare beneficiary in the United States, Medicare is not paying the radiologist or the U.S. facility that performed the test for anything done in India. And that one has stood the test of time. It is still on the books, and it's one that is causing angst. That physician located in India, Australia, Switzerland, Israel, wherever they may be, may have a license in the United States of America. But the fact that they did this outside the United States of America is the trigger point for this policy requirement. So it's one that those of you involved in coding and billing need to be cognizant of and make sure that things are not billed that should not be billed. Yet, at the same time, I think we're suffering from regulatory dyslexia because one side doesn't talk to the other. Under Medicare, under the beneficiary manual, in the preceding chapter, chapter 15, we have this on telehealth services. So you can see that there are some areas where there is no problem, but there are areas where we do have a problem. And the key is to put the coding and building in the right bucket. We've also had some recent seismic changes coming down at us from Washington. This is a bill that became law the day after tax day, Public Law 11410, and it's the Medicare Authorization and Chip Reauthorization Act. This is the one that got rid of the SRGs and a lot of other things. But they put in the definition of telehealth across various federal programs so that we can have one set. And to identify what are some of the issues that are inhibiting greater use of telehealth, and including the licensure issue, which now will be probably dealt with by the compact. Looking at privacy, which is a very big component here, and infrastructure requirements. And what the needs are in an urban setting may be very different than a rural setting, particularly when it comes to parity in payment. And then how CMS is going to monitor all of this. So it requires the Comptroller General of the United States within the next 2 years to basically get a handle on this. There are other changes, however, that Congress is looking at. What is this going to mean for us, those of us who are attorneys, for those responsible as a CFO, for risk management, for compliance? It's going to mean that there's greater interest. We're going to be lighting up the radar screen on the feds. And it could be, too, that we're going to see the John Wayne syndrome emerge. Get the process under control now, get out of my way program, get rid of all of these regulatory contradictions. And that might be nice if we can streamline, but what new risks will emerge from it? And that's where enterprise risk management will be very helpful, particularly as it relates to financial audit, financial accountability, and scrutinizing claims to prevent fraud and abuse. And when I say other federal entities or federal programs coming at us, I am not joking. This is the one that last week cleared the House Energy and Commerce Committee. It's H.R. 6, and this is the one that's got a lot of changes proposed in it that will address things like clinical research. It's called the 21st Century Cures Act. It's got a lot of bipartisan support. But one provision in it addresses, guess what, telehealth services under the Medicare program. They're looking at population health data. Well, remember, the question was asked earlier in the presentation, who owns the data? Who is getting the data and who's using the data? Population health would love to use this data. And CIMI, which is the innovation program that came out of the Affordable Care Act at CMS, is looking at the uses, models, and projects that will be funded through the Social Security Act for telehealth. And they're going to try to hone in on what are the high-volume procedures by code or diagnosis that would be amenable to telehealth and which should not. And again, look at the barriers to telehealth services. Well, that's great, but I'm going back one slide. Wasn't that also part of this, of the Public Law 114-10? So there's some overlap here. This has not been enacted into law, H.R. 6. It's still got to go down the road a way. But what it does demonstrate to all of us, if we're trying to anticipate risk as related to telemedicine and or telehealth, these are some of the things we should contemplate now. And then there is Texas. I'm using Texas as an example, mainly because it has been lighting up the internet in a battle over regulation as it relates to telemedicine. This is a change that was put in place in April by the Texas Board of Medicine to the administrative codes in the great state of Texas. It is a provision dealing with disciplinary guidelines. Notice that they're going in the opposite direction. Like the abortion provision, it's going that same route back to in-person or face-to-face evaluation, except when there's a behavioral health emergency or in mental health services. And they talk about what is necessary to establish a physician-patient relationship. This situation has been focused on one particular provider of telemedicine services who's been involved in litigation over this whole topic and recently got a stay from the court. And here is the injunction actually on slide 26. The argument that's being used by the plaintiff is an interesting one. In February, the United States Supreme Court made a ruling involving the dental board in North Carolina. And that ruling focused on the fact that the board, composed largely of dentists, wanted to clamp down on the availability of non-dental providers using or providing dental whitening services, basically cutting out the dentist, doing it on their own. And the board said, this is the practice of dentistry, you can't do that, and so they clamped down on it. The Federal Trade Commission got involved, and the Supreme Court took the case. And here's what the court said. When a board comprised of decision makers who themselves are active participants in the market, you can't hide behind state action unless the state is actually involved in supervision. Can't use that as the peg on which to hang your hat. So the litigant here in Texas is basically saying, if that's good for the North Carolina Board of Dentistry, the same should apply to the Texas Medical Board when it goes against the mainstream and requires in-person or face-to-face, except in mental health services or behavioral emergencies. The argument will be that they cannot show that there's active supervision by the state, and that the board is comprised largely, of course, of the very people who are in the market that's trying to be controlled. So this is a very interesting one. It could be a movie script, but it's certainly not settled law. But it shows something to those of us who are on this call who are attorneys or in regulatory compliance. It's not just billing and coding. It's not just licensure. This is now antitrust law coming to play. And there's also state antitrust laws that should be contemplated, but this is right now the FTC, and it shows how strident some people are becoming as it relates to the delivery of telemedicine services. Let's face it, a lot of this is about money. If that were not enough, let's move on to another risk, and that's insurance coverages. Do we have the professional liability coverages we need? Some of the participants today are probably in captives. You are in RRGs. You might have an high SIR, or you might have a traditional insurance tower. Do you have the right portfolio of coverages? Not simply professional liability, but also cyber risk coverage. If someone hacks your system and is able to get personally identifiable data, that is an issue. If you have a problem with the system you're using and the system doesn't accept or doesn't display properly a 32-bit read from a 64-bit read, or is delayed, or you can't get a motion study done properly, we might be tripping over the wires on something called tech E&O coverage. If your system is down, if you remember a few years ago, ladies and gentlemen, there was a situation where someone working on some undersea cables cut a cable off the coast of India. And that was really like cutting the pipeline to the internet for many entities. That's a business continuity issue for the provider of telemedicine services. Meanwhile, what does the critical access hospital do? What does the acute care facility do, the large physician group, the walk-in clinic, when all of a sudden there's no service, or they get a denial of service? Do they have the prerogative to go out and get a plan B, a substitute, and who's going to pay through the nose but them for that substitute service? Shouldn't they be compensated? Business continuity. And of course, heaven forbid someone lives in a part of the continent or abroad where there's a cyclone, a hurricane, a tornado, an earthquake that disrupts or destroys the property. You need property coverage. So what is your portfolio looking like, and have you contemplated these risks? There are infrastructure risks, and you're going to see on 28 different colors for a reason. Some states, and it's incumbent upon you to find that out for yourself, do have, in fact, requirements on technology for telemedicine. But there are all kinds of vulnerabilities. We know that through MU2 and MU1, and now we're talking about MU3, meaningful use, and the not sharing, we've got interoperability issues coming out of our proverbial ears. That's a vulnerability. HIPAA, security, HIPAA privacy, HIPAA high-tech. If you're contracting out and the contracted party has a breach, when do they let you know, and how do they let you know? What are the encryption standards, particularly as we're seeing more and more bring your own device by care providers to make sure that the mHealth using telemedicine or telehealth itself is using encrypted proper software. We need to have standardization for store and forward requirements, particularly as we're relating to images. Be mindful, too, that a lot of the providers are engaged all the time in software enhancements. Your IT department could probably collectively pull their hair out on the occasions when a software patch comes complete with a bug that shuts down your system or necessitates it, or is causing all kinds of havoc. So how do you know that it's been field tested before it comes to you? What's the response time when your primary telemedicine provider or telehealth provider doesn't provide a response? When can you roll over to the next one? And that's in yellow because that's a caution light from a clinical risk perspective. Another from a liability perspective is if I've got somebody in California doing telemedicine services or telehealth for someone in Massachusetts with a 3-hour time zone change, they may be dating it California Pacific time, but the patient is 3 hours ahead in Eastern time. And if it times and date stamps on Pacific, it looks like I pre-populated and could corrupt or impeach the credibility of the record. Also, how are reports documented so that you can have standardization and you don't have to go back and ask for clarification. These are all infrastructure issues. My favorite one is this one, believe it or not, and that is contracting risks. Be wary of boilerplate forms. Be wary of one-sided agreements that doesn't take the opportunity to allow you to even the playing field. How? As you can see on the screen, by getting rid of the use of subcontractors or giving you the right to refuse and the opportunity to cure or to get rid of them if they are debarred as a provider by Medicare or Medicaid. Those who are attorneys will tell you, beware of any kind of agreement that comes into your lap that references addendums, schedules, or exhibits, but none are present. There are billing and coding risks. This is a topic that merits its own discussion. And those who are the experts, the content experts in-house, are the ones who should be at the table in designing coding and billing practices relating to all manner of telemedicine and telehealth. We need to look at private pay or parity issues, which is something that a lot of states are dealing with now to try to ramp up the use of telemedicine and telehealth by making it equivalent to being in person. Medicaid and Medicare, very much in the forefront, as we've seen earlier, on billing and coding. We've got to be very careful about how we bill. Make sure you deal with the delays in payment, because that could kill you from a cash flow perspective. And there is a risk, depending on who's doing the coding, we could end up with upcoding that should not be there. Okay, that's enough to give a lot of folks indigestion. Let's go to what we can do to fix it. So the first strategy from an enterprise risk perspective is to identify your risk tolerance, not you individually, but your organization. How much risk are you willing to take in telemedicine and telehealth? What is the total cost of risk to your organization? Not just liability insurance or paying a claim or reputational loss or going through the rigors of a state agency or CMS kind of scrutiny. What is your total cost of risk? What kinds of infrastructure costs do you have to put in place? Training costs. And knowing that, what's your appetite for that risk? We can use a very simple type of ERM, enterprise risk approach, which would mean the first step is get the content experts, the lawyers, the compliance, the IT, HIM, the providers into a room and do a risk inventory for your organization related to telemedicine or telehealth or one project. When you get the risks identified, put them through the grinder of a SWOT or something like SWOT, strengths, weaknesses, opportunities, threats. That'll help discern or distill down what is low-hanging fruit, what are things that we should not touch, what we will have to treat as a risk. And that can be done by developing an action plan that looks at what risks am I willing to accept? What risks should we try to eliminate? Like, don't use that service. Are there some risks that I can adjust? Yeah, we probably could do a lot of things. And are there risks that I can transfer out through insurance or contract? Strategy 3, apply the ERM. Once I know where my risks are and the ones that I'm going to treat and I can fix, I think they're going to fall into some buckets that you see on the screen on 34. Contracting, credentialing, consent, that financial regulatory monitoring, the two-way communication, and then we're going to talk about, in strategy 4 actually, market trends. Let's look at some of these individually. If I am going to look at my action plan on contract, and I'm just using this as an illustration, what I want to do is make sure that the content experts, not just the lawyer, the content experts for telemedicine are in the room helping me design our standard contract. Looking at the organizational impact, not just one group in the enterprise. Define your own terminology. Close out any of the loopholes, like the ability for the vendor to subcontract or to sell the contract to somebody else without your prior approval. Build in contingency planning for situations where the provider's ISP has a denial of service and you need to go to somebody else to provide continuity of care. Specify, if you're going to use third parties, that they provide up-to-date proof of insurance, not faxed to you, but sent to you as a first page, as a first copy, with not only specified limits, but named insured. Check with your broker or your advisor on insurance coverages to make sure that the carrier that that individual group or entity is using is recognized as well rated. Get out of the subcontracting. Don't depend on somebody else to tell you when they think they're going to report to you. You specify it in your contract, including for breach notifications. Identify how we can cure deficiencies in the agreement and build in the ability to terminate. Once one signs the contract, you need someone in-house to monitor for compliance. Are the folks providing our services in telemedicine or telehealth doing it well? If I am the provider of telemedicine or telehealth services, we too need to have someone monitoring. Are we living up to our side of the contract? We don't want to get a termination notice. So it's a two-way street. But it's a good example of how getting the team together, you can form a wholesome contract that works for you all. Credentialing. Your governing body must make a choice. Do they want to take advantage of the conditions of participation for hospitals or critical access hospitals, basically proxy credentialing, or are they going to do it their own? You're not obliged to follow this alternative. It's just an option. And the board needs advice. It's got to look at the benefits and the risks, the costs, how you're going to control data, who's going to have access to the data, and be consistent in credentialing. One of the questions I have, and I don't have an answer to this, is can we somehow control that the vendor that we're going to isn't giving this data to someone else who's using it for population health, who can package it and use it and gain financial remuneration that way, even though it might be de-identified. Do we want that? Do our patients know that? So telemedicine is another, it's an agreement, it's another agreement here, but it's also a situation where you have to decide, do you want to do it yourself, or are you going to rely on someone else to do it for you? Telemedicine consents. The watchword is this: consent is a communication process. It is not a form, but we do need documentation to substantiate the process was completed. We do need medical history. Just think about the example of the gentleman who had the adverse reaction to the contrast media. And it is a process. It's a two-way street of communication. In the context of telehealth and telemedicine, that process must be compliant with state law requirements on consent and probably follow along with the wonderful suggestions from the Federation of State Medical Boards. Think, too, about how you want to document those consents to meet your state requirements and compliance requirements for reimbursement purposes. Another example for the financial and regulatory. Internal audit has got to be at the table now. They have to help you identify how you're going to be able to capture information for billing and coding. And this is not just for Medicare and Medicaid, TRICARE or CHAMPUS. Think about it. What's good for the goose is good for the gander. We are seeing these kinds of issues now pop up with parity at the state level for telemedicine and telehealth vis-a-vis in-person or going the remote route for reimbursement with health plans and insurance plans. So we need to make sure that the coding and billing is crisp and accurate. Monitoring here from an internal audit perspective also includes compliance to make sure that we are dotting the I's and crossing the T's, not only for purposes of HIPAA privacy, but HIPAA security and high-tech compliance. If you're going to be relying on proxy credentialing, is it going to include Medicare and Medicaid debarment, or are you going to be checking it too? And what about checking the Federation Disciplinary Bank, which is separate from NPDB, but also the National Practitioner Data Bank? There's nothing to prevent you from doing that. And the more you start thinking about it, you might come down on saying, rather than farm it out, maybe we'll keep it in-house. Once you have a monitoring system in place, anything that's a variance, that's worrisome, that might meet the definition threshold of an adverse event, serious event, reportable event, potential compensatory event, it needs to be jumped on then and there, even if it's an early warning of a problem, like a patient complaint that goes through patient relations. Those are variances that need to be reported. Our task in enterprise risk is to make sure that the right parties get the information in a timely manner so they can act on it before it becomes a claim. Two-way monitoring. Very, very interesting part here too. Use the contract as your quintessential risk management tool. Make sure you're getting the information you need, whether you are the provider or the recipient of telemedicine services. Have your legal counsel make sure that whatever information is going to be shared, if you're using proxy credentialing, you leverage whatever evidentiary protections you can under your applicable state law. And as you're looking at this, because much of the data may come through an EHR, think about working with a lawyer and your HIM or IT people to design now how you're going to deal with this data from an e-discovery and legal hold perspective, and who will be in control. Because you could end up with a lot of chefs in the kitchen not knowing which one is supposed to stir the pot first. Finally, here's our internal and external scanning. This field is changing with rapid pace. It's almost like a blur from one day to the next. What you put in place needs to be flexible. Don't cast all of this in concrete, because you're going to need a jackhammer to break the concrete. It's important when one uses enterprise risk management to do what we call market scanning and risk scanning. Risk scanning internally, but also in the environment in which we operate. So what are the market trends? How are we going to split up market share? What are the technological innovations? Am I going to lease or buy in order to maintain my currency in telemedicine and telehealth? What payment models are going to be conducive and what will not? And then we've also got to look at the laws, and certainly those are changing along with the regulations. Follow cases like the one that I gave you on screen, and watch for interpretive guidelines. Even though the interpretive guidelines from CMS are not law, it does tell you how they're going to imply the law, and that can be very useful too. So let's wrap up. We've got a few minutes for questions here. Here's the takeaways. This is a dynamic area. There are so many models emerging with all kinds of ideas about how to pay for it. There may be some relaxation of federal law, but at the same time, there may be some tightening up at the state level or slackening off. We need not to think in silo terms, those of us who are engaged in telemedicine. We need all hands on deck. In other words, use an enterprise risk approach. Recognize that you have content experts in-house who can be very, very instrumental for you. And then on slide 43, here are some resources for you in addition to the ones that you found on the slides. And I am going to turn this back over to you, Jenny.
Okay, I just have a couple of questions that people have sent in. Just as a reminder, please use the Q&A menu bar located on the GoToWebinar menu on the right side of your screen to submit any questions. But the first question I have for you, Faye, is on the subject matter of teleradiology interpretation. regarding date of service. If a radiologist interprets outside the state and the test result was sent to her via electronic secured email on the date the test was done, the radiologist interpreted the test after 2 days. Should the interpretation date be the actual calendar date that she interpreted it? Or, let's see, it says based on the example that you shared earlier, the radiologist was not available and missed.
Okay, I think it's got to be the date, personally. Others may disagree. The date of service, because you want it on the right date of service. Our big challenge right now is with EHR systems. Can I capture that this was done, A, in another location, and B, in a different time zone, so that it can show that using even as the convention Greenwich Mean Time, by the offsets from Greenwich Mean Time, the actual interpretation was done at this time using plus GMT, minus GMT, and it would then stamp when it was transmitted back to the party who requested it. If there's a delay in care, there's a delay in care. And or it may not be a delay in care. It may be that the contract gives them the prerogative to take X number of days to interpret. So it much depends, but if it's an urgent overnight and it was delayed times 2 days, that's a big problem. That could actually break the contract, let alone be a delay in care. So one of the things, that's why having content experts at the table is so helpful. It's to corner your IT software developer and say to them, listen, we're involved in telemedicine and telehealth. That means we have people who are doing services for our patients, our clients, whatever, who are in different time zones. We need to capture that as well as when we get it and how we use it for all the different purposes, billing, coding, treatment. So it's an excellent question. And getting someone to be able to develop the software accordingly could be somewhat of a challenge.
Okay, Faith, and another question that was sent in is, are there specific regulatory or risk management considerations for telemedicine services provided by a home health agency?
Yes, home health is using them. And another group that's corollary to it is the patient medical home. One sees it's more like telehealth than it is telemedicine per se. One can find for homebound certified home health agency patients that they may have a blood pressure cuff and they may have a stethoscope. They will have a two-way camera on their little computer, and they send in their results. They may even do if they're diabetic, they're going to do their blood sugar, and then when the results are received, the screen comes on, and it's a nurse or an LPN who is visualizing the client at home, looking at the results, checking how they're feeling, and that can be then determined whether or not that client is going to have a visit by one of the nurses from the home health agency, or whether they need to call the doctor to get an in-office appointment or call for an ambulance. So those kinds of things are going on. Are there conventions for it? Well, I think if you look at some of what the National Home Associations are doing, they've got some ideas. The telemedicine associations have their own ideas. If you're looking for examples of model protocols, one group to look at is to go to the website of the American Telemedicine Association. They've got a lot of interesting suggestions, and they continue to put out more that may be very helpful. And then look at the requirements under CMS and Medicaid, and check your state laws as well.
Okay, since we're at about 5 minutes after 1, we're going to go ahead and close today's meeting. As a reminder, the survey and CEUs will mail out within 24 to 48 hours. We'd like to thank you and hope that you have a great day today.